Good morning, everybody. Can everybody hear me all right? Everybody see me? Just before we get started. Yes, perfect. Great. Good morning, everyone, and thank you for joining this webcast on fair versus unfair dismissals and how we navigate conduct dismissals. So, as always, we've got a lot to get through today. We're going to be talking about the law on unfair dismissal and where it comes from. Conduct dismissals, we're going to be focusing on as the core topic today. So, the last time we did sickness absence, today we're going to do conduct. We're going to talk through process, have a chat about what gross misconduct is, look at some common errors, what the costs are of getting it wrong, some key documentation that you should be making sure that you have within your suite of documents. What our system does, so if you are concerned that perhaps there are some holes or things that you think you could use some additional assistance with, how we can assist you, and then also what could change, so what's coming down the line with that employment rights bill, particularly because we've had some updates this week following on from the parliamentary committee process. So for those of you who are new to us, we're heroes. So we're here to protect your business from the risk of tribunal and help reduce legal costs. So we are a team of employment specialists. So I'm an employment solicitor. So those of you who've worked with me or know of me, my bread and butter work is supporting small businesses and HR teams and HR consultancies, and also undertaking training, mediation, and investigatory work. We have also launched our software, the Hero software, which is built around my experience and the trip hazards that I've seen businesses make over the last 10 to 15 years. So let's get started and dive straight into the details. As I said, we've got quite a lot to get through today. So first of all, where does our unfair dismissal law come from? Well, at the moment, it's in the Employment Rights Act 1996, so in Section 98. This is expected to change, obviously, because in 2025, we expect the bill to be finalised, potentially not coming into force until 2026, but this is going to be replaced by the Employment Rights Bill. Now, it may well be that we see the Employment Rights Bill just adding bits and pieces into the Employment Rights Act. So for any of you that are particularly fond of this very long-winded and difficult legislation, it may not be departing us entirely. We may just be seeing lots of amendments listed out in that Employment Rights Bill. So what does Section 98 say? Well, it states that it's for the employer to show, so this burden is on us. We have to show that the principal reason or the reason why we have dismissed someone is either on a reason that's a substantial reason of a kind to justify dismissal. So that's our SOSR snuck in there. Or it relates to the capability of an employee, relates to their conduct, they were redundant, or they couldn't continue in a position because it contravened a duty or restrictions. That's that statutory restriction. So in much simpler terms, are potentially fair reasons that we can dismiss somebody are conduct, they did something wrong, capability, they're unable to do their job because of sickness or a lack of skills, redundancy, the job no longer exists or there's a reduced need. That SOSR, one of those, the favourites of mine, where we've got that insurmountable barrier to being able to continue employment, and then also those statutory reasons. So today we're going to be focusing on conduct. So we've got our potentially fair reason. And this is where we are looking at behaviour that is so bad that it breaks the employment relationship. So where the situation has gone to the very heart of an employment relationship and we have got no trust and confidence. Now, when we're talking about gross misconduct, this is the sort of behaviour that we are talking about. This behaviour that is so very bad that we don't think that a situation can continue with someone continuing in their employment. Now, if we've got lots of little instances where we've had someone who's, say, had several conversations about their behaviour, they've had their informal or their verbal warnings, they've gone on to a written warning, then a final written, and then we get to dismissal. At that point, we're really focusing on that trust and confidence and something that's gone to the heart of the employment relationship. So saying that actually, despite all these warnings, despite efforts to ask them to improve their behaviour or issuing guidance on their behaviour, and that they understood how serious the situation was getting, they continue to behave in a poor way. So actually, we've no trust and confidence in the fact that their behaviour is going to improve and that employment bond has been broken. But what we're going to focus on mostly today is that gross misconduct, those immediate dismissals where we're dismissing without notice or potentially with notice. The reason being, in my experience, when I've been dealing with employers and back in my litigious days when I was a tribunal lawyer, it was these instant dismissals that tend to be those that are that little bit more litigious, where you've got someone who's had that string of warnings and they get to the point where they are finally dismissed. We do still see tribunals for those instances, but I would say what is more common in my experience is where you've got someone who has got that out and out dismissal for gross misconduct. And that's often where we see some mistakes, either in process or in terms of that decision making around what is gross misconduct coming out. So that's what we are going to be focusing on today, is where we've got that really, really poor behavior. So we have our reason, conduct, now what? So we're not out of the woods. Just because we've shown that someone has behaved really poorly or we've got some really bad behavior, we still have to make sure that we don't forget that there's two parts to the test. So we have to consider, is the employer being reasonable? So this depends on whether in the circumstances, including the size and administrative resources of the employer's business, if the employer has acted reasonably or unreasonably in treating the reason they've selected as sufficient for dismissing that employee. Now, that's determined in accordance with the equity and the substantial merits of the case. So what a judge is going to look at is the reason that we've selected conduct. Have we been reasonable in relying upon that? And have we been reasonable in terms of, is it enough to get to dismissal? Now, we've done our first poll, so this one's a bit tongue-in-cheek, so just before we move on. Do you think Greg Wallace should undertake sexual harassment training? 93% say absolutely. 7% not sure. And thankfully, none of you think, I don't think so. So obviously, we're not passing judgment. We don't know if poor Greg has done this or not, given his statement yesterday. If you want to see my thoughts on that, then head over to my LinkedIn. Yes, I would agree. I think Greg Wallace does need a little bit of sexual harassment training. Thankfully, we provide it, so you never know, maybe the BBC will come knocking. So we have selected our reason. We understand we need to be reasonable. So what does this actually mean? So we need to ensure that we are acting reasonably, that we have a sufficient reason for dismissal. We can't just get to dismissal because we've decided we no longer like somebody or they've become annoying, or perhaps, we think this is going to become a repetitive issue and we don't want to be in this situation again in 6 months. It's got to be sufficient reason for ending employment. It's got to be serious. So is it fair in consideration of the merits of the case and taking into account employers' size and resources? So where you have got smaller businesses or businesses that perhaps don't have vast investigation teams, or the ability to perhaps sometimes take specialist advice, it doesn't mean that you're going to get off lightly with the tribunal, but your circumstances in terms of your ability to deal with a matter are going to be taken into account. So who decides what is reasonable? So we've got the virtual test. Now, if you ask ChatGPT what this test is, it gets it totally wrong. So do make sure that if you are wanting to check your knowledge around the virtual test, or if after this session in a few weeks, you're coming up to dismissing somebody and you think, oh, actually, what was it that Alyssa was going on about? Come back and check the slides or put it into Google, because ChatGPT does seem to have a bit of an issue with this concept. So what we have to be reasonable is a genuine belief. So we have to honestly have believed that the employee was guilty of misconduct. So where employers sometimes tripwire here is that they might have someone who there's been various absence issues, their work's not quite up to standard, and there's been various problems with them, and they haul them into a disciplinary and consider dismissing them on the basis of gross misconduct. Now, if we've got someone who's in and out of work a bit late, their hours aren't quite right, or their work's a bit substandard, have we got a genuine belief that they have committed misconduct? Or is that a capability issue? We need to make sure that we have selected the right reason and that we honestly believe that that is what is the salient issue that's in contention. So if we've got an employee where actually the evidence is a little bit thin, or we are not entirely convinced that they have done what it is that they have been accused of, then we need to make sure that we're not falling foul of this genuine belief. And where this test then moves on, so we talk about reasonable grounds. So we have to take that belief, and that has to be based on reasonable evidence or the facts that you had at the time you made that decision. So what the tribunal's essentially expecting is to get to that reasonable belief, you're going to have to show that you've done some investigation. Otherwise, you've got no reasonable grounds to base that belief upon. And if that investigation is one-sided, if it's biased, if it looks like it's just been a fishing expedition to support the employer's view, we're then going to fall foul of that third point, which is reasonable investigation. So we have to conduct a fair and thorough investigation before deciding to dismiss. So we have to have genuine belief. We believed that an employee was guilty of misconduct. It wasn't just a convenient reason. We haven't gone looking for something else and dressed it up as misconduct. We genuinely believe this person had done something very, very wrong. We've got reasonable grounds for holding that belief. So we've based it on reasonable evidence. So when we have come to making that decision, we can point at the reasons why we believed what we did. And that in doing so, we have conducted a reasonable investigation, and that we have been fair, thorough, and balanced in the way that we have done it. So substantively fair. So you may hear lawyers talking about whether something's procedurally fair or substantively fair. So procedurally fair is whether we followed a fair procedure in getting to our outcome. Substantially fair is this reasonableness. So it's whether the decision to dismiss has fallen within the range of reasonable responses that a reasonable employer might adopt. Now, this is what a tribunal judge is going to do. They're not going to substitute their own opinion over whether what you've done is right or wrong. They are going to look at whether what you have done fell within that range of reasonable responses that a reasonable employer might have done. So we have to ensure that the decision to dismiss and the sanction, so the decision that someone is guilty of misconduct and the sanction to dismiss are both reasonable. So if the judge is satisfied that an employee has committed misconduct, the judge may not agree that dismissal was appropriate. It could be that the judge thinks that actually a final written warning would have been within the range of reasonable responses, or that dismissal with notice might have been reasonable. So it's really, really important, just because we've gone through that reasonable investigation, we're satisfied that it's a conduct issue, that we really believe that someone had done something wrong, that again, we don't fall at this final hurdle and overdo it on sanction when all that good work that we've done could then end up coming undone. So was the decision that was reached one that was open to a reasonable employer? Now, you'll hear that word a lot. So if you've never spoken to an employment solicitor before, or you've never liaised with one either for your business or your HR consultancy, we talk about that word reasonable a lot. And that's one of the really, really key points that essentially the entirety of employment law, when it comes to dealing with employees, is that we have to be reasonable in the way that we are behaving. So if you're ever in doubt, my tip is always take a step back, take a cool head, and think, have I taken tunnel vision, and have I got involved in this? Have I got emotionally involved, or is this something that's got under my skin or pushed my buttons and I'm likely to overreact? Do I need to maybe talk to someone else and think, is this as severe as I perhaps think it is? Or have I got myself all wound up because I've been working on this process for months and months and months, and this employee is an absolute pain? So making sure that we take that step back, that we take a cool head and a calm and reasonable response to things before we make those decisions. So I've got a quick question that I'm just going to come to now. So employee who was AWOL, he forgot his phone, he tells us the following week. This is misconduct in our policy. AWOL again, no explanation. Tuesday, AWOL again tells us he fell asleep. Disciplinary tomorrow. This has become gross due to repetitive nature. My thoughts. So if it is something that's become repetitive and it's covered in your policies, then yes, potentially this is something that you could deal with as a gross misconduct issue, especially if the employee is continuing to do it and it's covered in your policy as that type of conduct. And I'm going to come on to that in a moment when we talk about what we list as gross misconduct in our policies. So then we're going to move on to something been procedurally fair. So have we followed fair procedures? So not only have we got to undertake a fair investigation, but we also have to ensure that the procedure is fair and at the very least meets the requirements of ACAS. So as a minimum, we need to make sure that we've done a fair investigation, the employee has been made aware and given the right to respond and provided with evidence before the hearing. So we don't present them with the evidence at the hearing, we don't sort of accuse them on the day, and we don't give them a heads up of what it is that they're on the hook for, and then once they're in the meeting go, aha, we've got evidence that contradicts everything you've just said. We have to front load it. We have to show them everything that we have before the meeting. We can't hold anything back, and we need to be very, very clear of what we're accusing them of. We have to give them the right to be accompanied, and when we are issuing that decision, we have to tell them why we've made that decision and also give them the right to appeal. Now, the procedural element is so, so important. And there was a case that was heard, or the decision came out in April of this year. It's Sainsbury's case. And for anyone who's been on training on some of the earlier webcasts this year that I've done, I've referenced this case a couple of times. And it's a fascinating case. It's there was an employee who worked for the supermarket, and he was found to have been taking the I think they're either 1p or 5p plastic bags. So he was doing his shopping at the end of the shift, hitting no bags on the self-service, bagging up his shopping and going. So essentially he was stealing plastic bags. And Sainsbury's won. There were no other aggravating factors. You know, he wasn't also shoplifting avocados, because we all know how expensive they are, or, you know, putting booze in his backpack or anything like that. This centered on plastic bags. And what Sainsbury's said was, we are very, very clear in our policies, very, very clear in what we publish around our site, that we have a zero tolerance approach to theft. Regardless of the value of the item that you take, it's a zero tolerance approach, which with a business of that size, you can understand. If every employee, and they have tens of thousands of employees, if every employee took one bag, it's all eventually going to mount up. But their policies were very, very clear. Employees were very clear on what the stance was. And the judge agreed and said, actually, the value of the individual item in this case had no relevance. The employer was clear on their stance on theft. The employer was also very clear when it came to value, and procedurally, they handled the matter appropriately. Now, it's interesting that there's actually two plastic bag cases that I like to refer to. There's this one, and then there's one where you've got the employees. I think it's from a supermarket that's gone bust now, where the employees are putting them on their head and running around on YouTube, and the supermarket was trying to say it was reputational damage. On that one, they lost that one. But the Sainsbury's one is actually a really, really interesting case when it comes to looking at what gross misconduct is and making sure that we're responding reasonably. Because most managers, when I put those facts to them in training, will say that because it's a plastic bag, they don't think that actually it's gross misconduct. So it's a really, really valuable case to look at when it comes to procedure and making sure that employees are fully informed and aware of where our standards of behaviour sit. So for something to be procedurally fair, so we've got to get those two elements right. We've got to be reasonable in what we're doing, but we've also got to follow the rules. So we've got the investigation that's got to be balanced and not biased. Do we suspend? Now, the rules around suspension have been, I'd say, updated rather than changed. Suspension can sometimes be a bit of a knee-jerk reaction. If we've got someone potentially on the hook for gross misconduct, that there is that immediate kind of reaction that we want to suspend somebody. Now, the reality is that we should be going through a bit of a checklist in relation to suspension, and I do actually have one. So if this is something that piques your interest a bit and think, oh, actually, we do fall foul of that a little bit, we do sort of just suspend people automatically, or actually we don't do it because we're concerned that we may not be doing it right and it worries us a little bit, drop us a comment and we can send out that checklist. And also I'll look at putting together potentially a draft suspension letter that we can send out as well. But what is really, really crucial is that we can honestly say that this is not a disciplinary act. So suspension should be where we are concerned that we can't fairly investigate with them on the premises, where there's a concern that they could potentially destroy or damage or hide evidence or intimidate witnesses, or where their behaviour is so poor or it's fallen below such a standard that we think that there is some sort of risk. So I do a lot of work in the care sector. So I work with care homes, and where we've got people who are accused of abuse, and until we've kind of got to the bottom of a situation for the safety of potentially residents, that we need to suspend them until the investigation and disciplinary matter has been concluded. So it looks like that's quite a popular request. So we'll get that out to you all as well. Now, the employee needs to know what they've been accused of and in enough detail to be able to prepare and defend. So one of my favourite examples to give here is where you've got an employee who, by way of example, has taken stock from a shop floor and has taken it home with them and not returned it. Now, the knee-jerk reaction there is to want to accuse someone of theft. Now, the legal definition of theft is someone who has permanently deprived somebody else of property and they've got the intention of keeping it. So if we pull that employee and accuse them of theft and they say, oh, well, actually, I taken it home, I was going to buy it, decided it didn't fit me, so I was going to bring it back, didn't see what the problem was, sorry, I forgot to tell my line manager I was buying some stock. Have we got enough there to reasonably believe that they were intentionally and permanently going to deprive the business of it? What I would be accusing that employee of is removing stock without permission, retaining stock at home without informing their line manager, and not returning it promptly. So there's 2 or 3 things there that we can use as potential allegations rather than going too broad or using legal terms. And actually, in that instance, if we say theft, an employee might not actually realise what it is that we're accusing them of. By breaking it out into those specifics, you're not going to have an employee who comes back and says, well, this process is totally unfair because I don't actually know what you're saying, what I've done. So making sure that we are being very, very clear in that list of allegations, because that is something where I do see employers tripping up because they're not specific enough in terms of what they're accusing an employee of. So what I've got here is, can we use CCTV footage as evidence if an employee has left site whilst on shift? So in principle, yes. What I would ensure that you have in place is a CCTV policy, and also that it's covered in your data protection rules as well, to ensure that whatever you say that you're going to use CCTV for, that monitoring employees is one of those uses. So yes, potentially, but just make sure that your policies are up to date in that respect. So once we've got someone who knows what they've been accused of, we then move on to the hearing. So we do not make a decision before the hearing. We need to approach the hearing with an open mind. We need to listen to all of the evidence, and we need to make sure that we are allowing other points of view as well. So this is not us charging down the train tracks, having an employee in our sites and essentially feeling like we're lawyers in court and that we're cross-examining people. We need to be asking questions, listening to responses. We're not speaking over people. We're not interrupting. We are allowing someone to have their say. We're allowing someone to defend themselves. So if you ask somebody a question about why they've behaved in a certain way and they start to give you an answer and you go, no, that's rubbish, because you know that we have got these certain standards of behavior. Allow them to finish talking. Allow them to have their say. You can counter their points. You can come back and ask them further questions and further probing points, but allow them to have their say. Because again, one of the things that I have come across in tribunal hearings is employees who say, I sat there and I was basically told everything that I did wrong, wasn't given the chance to have my say. The decision had clearly been made. We were just in that hearing so that they could say that they'd had one. And then the decision was essentially a foregone conclusion. When we do come to drafting that decision, make sure it is clear and well reasoned. This is why we have made this decision. This is why we have found you guilty. And this is the reason for the sanction that we have been given. So really, really explain ourselves in lots and lots of clear detail as to why we have made that decision. The reason being that, again, when that employee wants to appeal, that if they don't know why a decision's been made, we're undermining the appeal process. So we're not giving that employee a fair shot at challenging the decision that's been made. So Joe, so as a recruitment firm, we place candidates into clients. Hi Joe, Joe's on my lifeboat crew, so it's great to see you on here. There've been a couple of instances where they're dismissed and we have a rebate period. How can we ensure that our clients follow fair dismissal procedures for both the candidate and to protect our fee? So in that instance, you could require that they follow set procedures that you have agreed. So if you're working with them and it's going to affect you financially, I'd be looking at potentially tweaking your terms and conditions, so to make sure that if they fail to follow those processes, that's going to affect the rebate. But that's something I'm happy to pick up with you, Joe, afterwards, if you want to go through it in more detail. So common errors that we come across: insufficient investigation, where a decision has clearly been made in advance; overestimating gross misconduct, so choosing something, saying it's gross misconduct, and actually it's not particularly reasonable to say that it is; non-compliant documentation, so letters that don't have the requisite elements to them; outcome letters that aren't giving the reasons for a decision; not allowing somebody an appeal; confusing the fair reason, so accusing somebody of misconduct when potentially it's a capability issue; unclear allegations, so where we were talking about making sure that we've got that really nice, precise list, or then actually dismissing somebody for something else entirely that wasn't on the list to start with; calling something gross misconduct that in your policy isn't gross misconduct. So particularly if you've pulled a policy off the internet, or if you have got one that was drafted for you or provided to you — I'm being very generous by saying drafting in some instances, depending on where it's come from. If you've had one given to you and you've gone, great, I've got a policy on the disciplinary procedure, but you haven't read it to see whether you agree that the conduct that's in that gross misconduct list is actually gross misconduct, have a look to see what's in there and see if it needs updating. Or forgetting that you have a policy entirely and ploughing on with what you think feels like a fair procedure until an employee flags that you do have a policy and that you haven't followed it. Now, what I'm going to show you now in terms of tips and tricks is this overestimating gross misconduct. And it's something that in our system was a point where I really wanted to be able to help employers to put the brakes on before sometimes they make a decision that they can't take back. And what we have within our system is what I call the disciplinary decider, that Dawn one day is going to come up with a much better name for it, that sounds much fancier for all our marketing stuff. And what this does is it will take you through your decision-making process and it will give you a recommended outcome. So what we're showing here is that we've got an employee who's been employed for more than 2 years. We'll have a situation where we're very certain someone's committed the conduct. We've got some corroborating witnesses. It's really, really serious behaviour. We're not sure we can ever trust this person again. And actually this one, I'm going to just pause there. I'm trying to remember the facts I put into this one. Oh, I know. This is someone who crashed their car on the way to work and then refused to take a drugs test, and they injured another employee. So here we've got somebody was injured, it's a breach of health and safety rules, drugs and alcohol were involved, and we're considering informing the police. I'm sure we don't need to be a genius to think what the outcome of this one's going to be. It was the first time this has ever happened, but it was very, very serious. The employee did express remorse, but only after being told it was expected. Mitigation, there's long service and this person actually had a clean record. Any aggravating factors? We have got that in addition to breaking company rules, it's also illegal, and it affected another employee in a negative way, and it caused workplace disruption. Dismissal without notice. So the system agrees with the outcome in this situation. Now, interestingly, when we put the Sainsbury's case into this, it actually agrees that with the plastic bag example that dismissal would have been appropriate. So this is a really, really good tool, because what I found in terms of those who've either been testing this or using this is that where they've got an instance that they think something is gross misconduct or is sufficient for dismissal, that the system will come back sometimes with final written warning or dismiss with notice, or even where it's identified some risk factors. So if, for example, someone's on maternity, or if there's been a TUPE transfer, or if there's been a flexible working request, or if actually we've got someone who's committed this conduct before and the other person wasn't dismissed for it, so we've got an inconsistency, it's going to show you that there's an elevated risk and that you need to consider taking advice before you make that decision. So the cost of getting it wrong. So the basic award is calculated like a redundancy payment. So a week's pay is now capped at £700, and hopefully we all understand about the multipliers, so depending on somebody's age. The compensatory award, so this has gone up actually. So I'm just going to give you the correct figures here now. So because I believe now we're at £115,000 for this. Just give me 2 seconds. I'll double check before we come back at the end. So yeah, £115,000. So 115 and 115 is basically what the maximum award is. So I'm just going to put that in the chat there. So compensatory award, that is now the maximum. The maximum for the basic award is £21,000. So we are looking at some fairly substantial figures if we get this wrong, as well as the ACAFT uplift of 25%. And not to mention, if we then fall foul of other things like discrimination, whistleblowing, we could be getting into some serious hot water. And I've actually had a look at what the statistics were for the 2023-2024 period, and the average award for unfair dismissal has actually risen by 15%. So the average award 2022 to 2023 was £11,000, just under £12,000 for an unfair dismissal. It's now up to just under £14,000. So these awards are starting to climb, and obviously with the changes that we're going to see under the Employment Rights Bill, that 2-year period is going to disappear. Now, if you have been reading on LinkedIn, or you've been on some training where people are saying the 2-year period is going to be reduced to 9 months or 6 months for that probationary period, that is not correct. It's not reducing. The 2-year period is going. It is being deleted from the legislation. That also means there'll be no going back from this point. What we are hoping that initial period, or the statutory probation period, as some people are starting to call it, is going to give us a reduced burden in terms of how far we have to go to be able to get to dismissal, so that we aren't going to have to jump through as many hoops as we do at the moment for the post 2 years, or that the compensation is going to be capped. So it isn't that 2-year rule is being reduced. The 2-year rule is going. It's just that there will be this set statutory initial period or probationary period where we're hoping there's going to be a less onerous job that we have to go through to get to dismissal. So at the moment, it's less than 2 years, we're safe. Well, no, we're not. So there are the automatic unfair dismissals. So if we dismiss someone because of pregnancy, maternity, family-related rights, for whistleblowing, health and safety reasons, trade union-related reasons, discrimination, for exercising a statutory right, so that includes flexible working. If we dismiss someone because they've made a flexible working request, or if they think they've been dismissed because they've put in a flexible working request, then they could potentially bring an automatic unfair dismissal, which means they don't have to wait 2 years to be able to bring a claim. Or if it's minimum wage related, working time regs, if they've got part-time status and they've been treated poorly because of that, if they've engaged in industrial action because of TUPE, if they've acted as an employee rep, or refused to work on a Sunday if employed in retail or betting, or they've exercised their rights in relation to being a trustee of a pension scheme. If any of those apply, the 2-year rule disappears. And what we're seeing increasingly is that flexible working one, which is why I kind of emphasized it a bit there. It's where we've got the day one right now to request flexible working. If someone is then treated negatively because of that request and they decide that they're going to resign and claim constructive dismissal, the 2-year rule has gone out the window. So we need to make sure that we are still following process, that we are still following ACAS code of conduct, the legal advice that you might be given, even if it's less than 2 years, because there could very well be other issues bubbling under the surface that can present additional legal risk. So how confident are you with dismissals after the 2-year rule? So 21% very confident, 57% not sure, 21% of you not confident at all. So we need to make sure that we are working on that capability before the Employment Rights Bill comes in, because whilst we have got a bit of time at the moment, we have got that ability with that flexibility to some extent with the 2-year rule. It is going one way or another. So it's really, really key that we spend this time making sure that our managers can deal with people fairly, that they know our procedures inside and out, that they know what a fair dismissal looks like. So, and it's part of one of my bugbears at the moment is people selling you guys training on the Employment Rights Bill, which at the moment is a waste of money because we're still going through committee phase where things are being changed. What we need to be focusing on is making sure that the people who are making the decisions to dismiss, the people that are operating these procedures, can do so compliantly, fairly, and that they understand what they can and what they can't do. Because we are going to lose that runway and that latitude in 2026, and that is where your resources are best spent at the moment. So we've talked about the fact that we're going to have the removal of the 2-year qualifying limit, that we may be looking at a statutory probation or initial period, but again, we're not clear on what that necessarily means. So from day one, if we get a dismissal wrong, there's going to potentially be legal risk. Now, key documentation, so a bit of a list here for you. So just to check at your end, do you have investigation templates to help people who are perhaps doing investigations? Do you have a compliance suspension letter, your invitation to hearing letter, your outcome letter, invitation to appeal letter, your outcome for the appeal, and also your disciplinary policy? So making sure that you have got a good, solid suite of documentation to rely on. So, Becky, I've got a question here from you. So, I'm assuming that's if misconduct is repetitive, but with gaps of instances in between of over a year, can we still rely on as repetitive? So, that's a really good question because it brings us on to warnings and patterns of behaviour. If you have a warning that has been put on file and you say this warning is live for 6 months and it expires, and then at month 7, or in this case, a year, somebody then repeats that conduct, you can't necessarily use the warning to say, right, well, you've got written warning, you're going straight to a final written warning. But the way I word my warnings when they're issued is that even when this warning expires, if there is a repetition of the same conduct, it may be referred to show a pattern of behaviour. So that when it then comes to looking at sanction and what's reasonable, we can kind of have our cake and eat it. Now, if we're looking at dismissal, we need to be careful, but it could well be that you look at an additional. So, if you're at warning, it might be that you go to final written if we have got behaviour that is mirroring something that they have already been warned for. But it's important that your warnings have that level of detail as to, what we are expecting from future conduct. So really, really good question. It doesn't mean just because something's expired or time has gone on that we can't refer to it, but it's important that we're not necessarily referring it to, or we're escalating this because you've had a warning, but because we're showing that there's been a pattern of behaviour that hasn't improved. So what we're going to have a quick look at now is how we can potentially help you solve your problems. So I'm going to show you a quick snapshot of what our system does. So here we have got a manager who has gone into the system, they've gone into the employee dashboard, we've selected our employee, and we are starting an investigation. So the employee here is called employee tester. This is our test system. I've elected myself as the investigating officer because you got a notification if you've been appointed to a role, so I don't want to spam anyone else on my team while we're doing this. And we're going to put the details in. And what you'll see on the right-hand side here is that there's the notes that are going to give you guidance on if this is your first time doing an investigation, what it is that we need to do. So let's look at what this employee is accused of. So this is the employee who crashed his car at work. He destroyed company property, injured a colleague, and refused a drugs test. So here we can see the guidance. We're going to open the investigation. So we're going to interview some employees. So the employee through the system is invited. They get their invitation as well as a notification. We can drop any evidence. I'm just going to skip back. Sorry, this is a bit fast. We can drop any evidence into the evidence and documentation section here. We can see who has been invited, and then the disciplinary details at the bottom. So moving on to concluding. This then gives you the ability to type up your investigation notes in here. So I'm putting my investigation report here, and I consider there's a case to answer. Now, if you are someone like me who likes to have everything on one page, you can see here the interviews that have been done and any documentation that's been dropped, so you can refer to it whilst you're writing your report. We move on then to make the decision. So the allegations, we're going to be nice and specific here. So we've got refusal of a reasonable management instruction in relation to a drugs test. We've got they've arrived at work under the influence. We've got behaviour which caused a colleague to be injured, and destruction of company property. We think there's a case to answer, and we're going to select our disciplinary officer. Now, suspension. At this point, again, because suspension is such a topical issue at the moment, we've got some really, really good guidance on what we should be doing in a suspension situation. And if we want to suspend an employee, we've got the warning about making sure that the employee has been informed first, but rather than just sending them a letter saying that you've been suspended. So we're absolutely using best practice here. This then takes us on to drafting our invitation letter. So here sorry, no, this is the suspension letter. So this will take you through the employees not to perform any duties, they're not to attend company premises, they're to redirect and out of office, leaving their laptop. If they require support, because remember, this is a stressful situation for that employee as well, who to speak to, and then it previews the letter that's been populated that will then be sent out. Now we are populating that disciplinary letter. So we've got the allegations up here. There's our guidance on the right-hand side about the invitation. And here we have selected what the minimum and maximum sanction are. So you can see we've selected written warning there as the minimum. The maximum is going to be dismissal without notice. And we're actually now scheduling that meeting. So that will send a compliant invitation letter out to that employee. The system then takes us on to being able to compile the meeting minutes. So if there's a trade union, if there's a note taker, if there's anybody else who's present, if they've brought a companion and what the status of the companion is. And then what this does is it takes you through the tripwires that I identify when I used to litigate. So we've thanked everyone for attending the meeting. The disciplinary officer ticks to say they've done that. They've run through housekeeping. They've explained what the allegations are. They've confirmed that notes are going to be circulated and produced. That they've confirmed if any materials or evidence were sent in by the employee that has been received. So we confirm all of that at the start. We can then put our meeting minutes in the box here, and this is going to then compile our outcome report. We've then got the disciplinary officer is confirming that each allegation has been put to the employee a final time. And this, again, is one of my top tips. When you get to the end of a disciplinary meeting, you say to the employee, I'm going to put each allegation to you one more time, just so that we're clear whether you are accepting or denying the allegation. Did you crash your car when you came to work? Yes or no? Were you under the influence of drugs? Yes or no? Did you refuse a reasonable management instruction? Yes or no? And the reason being, even if it's a bit repetitive, is every single allegation has been put. And it's very, very easy in the heat of the moment to get into the nitty-gritty of a disciplinary meeting. And when you get out, you realize actually, there's an allegation that you forgot to put to the employee, particularly where there's lots of them. So by having this tripwire at the end to say that you confirm that every allegation has been put to the employee, that we thank the employee for attending the meeting, you ask them, is there anything additional that you would like to add? Is there anything you want to say? Because again, I've seen time and time again, the criticism, I didn't get the chance to have my say. There was something I wanted to say and I wasn't given the opportunity. So we're giving that employee the final opportunity to say something before we then confirm that the meeting has been closed. And what we then have again is a further brake pedal. Do we need further investigation? So actually, if we come out of that meeting and think, actually, this isn't stacking up, I don't think we've done a good enough job of investigating here, we can then go back a step and we can say to the employee, well, look, you've had your disciplinary meeting, we've adjourned it, but actually we think this needs further investigation. So what it's doing is tying you down to making sure that you are being compliant with what you are doing. So we've then got the ability to select the sanction. So here we're saying dismissal without notice. We've already been through the disciplinary decider. So there's your button there that takes you so that you can check to make sure that the system agrees that the decision is as serious as we think it is. We've then got the list of allegations. So we can say if it's upheld or not, and we're going to give our reasons. So refusal to follow reasonable management instruction. We're saying that it's a matter of fact the test was refused. The instruction was considered reasonable due to the events leading up to the incident. And we put all of our reasoning in here. And what this does is it then transfers it to the outcome letter. And so again, what we're doing here is we're taking some of this work away from you so that, as you'll remember in my top tips, what I've said to you is make sure that we are saying what someone's been accused of, why we found them guilty, and what reasons we have for the decision making. Is by following all of these steps, that's going to be in that letter automatically for you. We've then got the appeal is dropped in. And if an employee phones you and says they'd like to appeal, we can actually start the appeal process. But also from the employee side, they also get an appeal button that they're able to push to then commence their appeal. And we can acknowledge that then if that comes in digitally as well. So The reason why all these steps have been put in there is because it's where I have seen as a practitioner the things that trip up really, really capable employers, senior managers, and really, really solid HR people. It's particularly where we're dealing with very, very problematic individuals, or perhaps policies have changed, or perhaps there's been legal changes, or we've got a huge amount on our plate. Is what this does is it strips out all that administration, means that you can get on with making the strategic decisions, making the decisions about the conduct, and all the headaches and the legal compliance issues are just in there and taken care of for you. So what to do next? You'll be glad to hear that's the end of the plug. So thank you. So to do a demo on our system, please, if you would like to have a look at the software, you can book a demo. I think there's a call to action at the top of the screen. Make sure that if you feel that your managers need additional training, so looking at the poll there, I can see that you think that management in the business potentially needs training, and potentially you and your management team need training. We do offer training on employment processes and around this sort of thing. So looking at disciplinary stuff, capability stuff, long-term sickness, discrimination. I call it Employment Law 101, how not to get sued. So if you are interested in that, then please do drop us a message and we can look at providing you with some scope and quote for that as well. Make sure you update your key documentation. So we will be sending out the stuff about suspension, but also keep an eye on our LinkedIn and further events, because we do give out freebies all the time. And just remember, there is going to be less scope for errors in 2026. So now is the time to be schooling up your managers and making sure that we feel really, really comfortable with running these processes and how we make the decisions, because that's where we need to be focusing our resources so that we're ready for change. So if you do feel like you need legal advice, I'm branded as HR's guardian angel, so I'm always happy to be in the background for HR teams, HR consultants, if you feel like you need some really, really kind of robust legal advice to back up the advice that you're giving to your clients. I'm a dirty little secret for lots and lots of HR consultants. Their clients don't even know I exist. So I am happy to take that role. So if you feel like you do need support in helping support your clients, then please don't hesitate to reach out. For those of you who listen to the podcast, thank you so much for continuing to push us up the charts. We're at number 16 this week, so that's great. This is where myself and my co-host Ollie go through real world HR emergencies, where we talk about real situations that I've dealt with and the advice that we have given to clients, and how those stories sort of ended. So thank you so much for listening. We are now scheduling, I think, into the new year for our next webcast. I'm going to glance at Dawn just to make sure it's the New Year's resolution one, isn't it? So the things that as HR we should be thinking and doing in the new year. So whether that is dealing with all the sexual harassment stuff that's gone on at Christmas parties, I'm joking, all your Christmas parties are going to be amazing. There's going to be no problems whatsoever. So whatever it is, whether it's a clean up after Christmas or planning for 2025, that's where we're going to be covering all of that good stuff in our next session. So thank you so much for listening. We will be releasing the slides, and I've said those free resources as well, and hopefully you'll all join us at our next event. And it's been a pleasure to have you on the session again today, so thank you for giving me part of your morning.